Aldrin, it's been a long day for you, and you're probably halfway through getting your constitutional law degree after hearing all of those arguments. What did you hear?
Well, certainly after this, I think I can stand in front of Chief Justice Mogoeng and argue for or even against the secret ballot. And that's the arguments that the court has been hearing this afternoon in terms of the discretionary power, whether the Speaker of Parliament has discretionary power in terms of allowing a secret ballot. Remember that in her heads of arguments, in her responding papers, she said that there is no discretionary power that she has as a Speaker of Parliament, and that's the reason why she couldn't agree to the application that was made by 3 opposition parties that the motion against President Jacob Zuma, which was scheduled to be heard on the 18th of April last month, be voted on via secret ballot. And now we've heard all sorts of arguments here, and of course as well the concession that came from the council representing the Speaker of Parliament, Senior Counsel Moerane, saying that it would appear as though that the rules of Parliament does allow the Speaker to allow the secret ballot. And just quickly, just want to bring in the DA at this point. Just a quick sum up of what the arguments that have been made at this point, and of course the concession, I think, which is quite important, not only from the Speaker of Parliament's counsel, but also from President Jacob Zuma's counsel, Mr. Siminga, saying that there is no downside to having a secret ballot.
No, and I think it's an important provision. I think the more compelling argument was the protection of the members of Parliament, because as individual members they come to exercise their right. And I think beyond that, it says that the President must be held accountable, that I think as soon as we possibly can, we need to schedule that motion and ensure that we can move on to the business of South Africa, and making sure that we can hold not only the executive to account, but move on to holding the whole ANC to account, because previously they've relied on that to protect Jacob Zuma. Now the question becomes, how do you ensure that you remove the whole of the ANC so that you can move on to the business of the people of this country?
And I think the arguments as well raises some critical aspects around South Africa's governance system, as well as the election of members of Parliament being on a party list. That was one of the things that was raised by the justices as well. Do you think that perhaps this is something that we should be rethinking as a country?
We've always held the argument, as the Van Zyl-Slabbert report came earlier, which is to say there must be a mixed system, so that we can address the accountability question, that it doesn't just rely itself on parties, but it can also go into communities. So there were much broader issues that we need to discuss. But what we are dealing with in the short term is that if you deal with a political party that also protects one individual leader, then you end up with these challenges. I really believe that the more MPs understand that their role is to serve South Africans, the better they are in that space. And I think if this judgment helps us get closer to that point, the better it is for all of us.
Chief Justice Mogoeng earlier on also spoke about the removal of the President, and saying that why shouldn't you put your hand up, why shouldn't you show that this is me, be it Mmusi Maimane, and I'm voting against President Jacob Zuma? Why shouldn't it be clear in terms of open democracy, so for everybody to know that Mmusi Maimane has decided to vote against President Jacob Zuma? And he says that the removal of the President could be destructive, even more worse than junk status, and some argue that this is indeed a compelling argument. Even if you listen to the closing arguments now by Dali Mpofu, where he speaks about the removal of the President in terms of Section 102 of the Constitution, that of course would mean that the entire executive must resign, including the deputy ministers. This could indeed be destructive.
It is the one compelling argument that gives that sense of protection. And the biggest protection says, if in that case you would have such consequences, and it was the right thing to do, recalling the fact that the President was found by this very court to have violated the Constitution, then it becomes then without doubt that in fact that protection must be given to MPs in a world where there have been threats coming from Luthuli House on MPs. I still maintain that with or without the secret ballot, it should always stand that to do the right thing, boldness, as the Chief Justice maintained, cannot be something that is abnormal. Boldness must be something that we uphold, and that in fact you should be able to do it publicly. And I still maintain for the people of this country that I'd never shy away from voting publicly to say Jacob Zuma must be removed.
Well, Chief Justice also makes the case, and quote unquote, he calls it's quite an interesting case, that it would seem as though that the smaller political parties in Parliament, following from the EFF going down, are protecting members of Parliament from the ruling party, the governing party, as well as the main opposition, the DA, because both the ANC and the DA is not party to this case. Can you just take us around the decision for the DA to decide not to be part of this case, however showing solidarity in terms of the decision by these opposition parties, especially the UDM, to bring this case to the Constitutional Court?
We maintained without doubt, our stance was that we'll comply with what the Constitutional Court puts forward. And there's no question about that. We maintain that that's the stance. But the real challenge in this instance is the fact that for us, we're saying in a world where we maintain that there's a case against Jacob Zuma, secrecy should not be the inhibitor. I will always stand up and say publicly I will vote to remove Jacob Zuma, because it is the very essence of what consciousness would mean in our interpretation. And so that's why we said we'll comply, that either way it makes no material difference to us, because we maintain that we must uphold our oath of office, defend the Constitution and remove Jacob Zuma.
Just a final one, the argument around MPs voting according to their conscience has been something that has been going on and on in terms of the arguments that have been made in the Constitutional Court. And some might argue that the DA on its side, in terms of its constitution as well, it instructs its members of Parliament that, listen, that you must toe the party line, and if you don't toe the party line, you would be de-seated.
This is about a PR system. In a PR system, you have policies that the party goes for. Imagine when we stand up to voters and say, our policy is this, and then when you get to Parliament, somebody goes against that. That's why that provision is in place. That provision is not in place so as to defend criminality, so as to defend somebody who's violated the Constitution. It is in place to ensure that at times such as this one, members of Parliament have the right to exercise their consciousness. So I don't think the two matters are the same.
Well, we have to wait and see how this Constitutional Court justices come to a finality with regards to the powers of the Speaker of Parliament with regards to ensuring that the President is held accountable. Just a quick one. I know that we're running out of time. We see here we have the leader who's also the main applicant, the leader of the UDM, which is the main applicant. Are you convinced at this point that after the concession by the Speaker of Parliament's Council and now also President Jacob Zuma's Council, that the Speaker of Parliament does have discretion when it comes to a motion of no confidence being conducted in a secret ballot, that will indeed happen?
There is no doubt in anybody's mind that we have been vindicated when we originally said the Speaker has got discretion and she should use that discretion. But today they considered that indeed she has the powers to conduct that voting through a secret ballot. We welcome this concession.
Just finally, why was it so important for the UDM to make sure that this thing is being ventilated in court and it comes to finality? There has been also the argument, which was brought up by the President as well, that this court doesn't have jurisdiction as it stands at the moment, that the UDM should have gone to a lower court before coming here.
Well, we know that of the three arms of government, the Parliament as well as the executive have failed this country. We knew that if we come to the Constitutional Court, we will get a fair hearing. And as a result, people here were tumbling all over themselves. And we are confident that we will get a better judgment.
UDM leader there, Bantolo Misa, thank you so much for your time. Indeed, we'll have to wait and see exactly how this is going to unfold. I see that the leader of the EFF is also currently giving a press briefing, going to see if he'd be able to just squeeze in quickly and hear what his reaction is to some of the arguments that have been advanced inside the Constitutional Court.